members, we've got a quorum already, so may I now call the meeting to order. We've got 2 papers issued since the last meeting. They are information papers. First of all, letter from Mr. Dennis KWOK requesting for inclusion of an item on review of the implementation of civil justice reform. And then we've got another paper, CB48531314-01, the administration's paper on draft live television link, witnesses outside Hong Kong rules and draft rules of the High Court amendment rules. Concerning Mr. Dennis KWOK's request, that has been included in the list of outstanding items for discussion. In fact, the list was issued to members on the 6th of June. As at the 13th of June, no objection have been received from members, and that's why Mr. KWOK's item has been included in the list of outstanding items, and it's item 19. And then concerning draft live television link, witnesses outside Hong Kong rules and draft rules of the High Court amendment rules. So can a briefing be given to members, and then members can have a discussion. I believe members have all received the paper. That's paper CB4853-01. I think that paper is quite long, and I think it's desirable to invite the administration to come to brief us on the rules. And then we've got paper CB48221314-01, list of outstanding items for discussion. And then we've also got paper 02, CB4822, bracket 02. Now, in fact, we've scheduled a meeting for the 22nd of July at 4:30 p.m. and the items to be discussed include development of mediation services in Hong Kong, and also provision of accommodation support for law-related organizations in the West Wing of the former central government offices and the former French mission building. And the administration has told us that in a paper on the development of mediation services in Hong Kong, the issues relating to the role and functions of the Hong Kong Mediation Accreditation Association Limited will also be covered. So members can consider discussing the 2 items at the same time. In other words, item 1 and item 2. So the first 2 items will be discussed in the July meeting. Deputy Chairman. Chairman, concerning the use of the former French mission building, I think there is a need for us to invite deputations. For example, the International Arbitration Center and also the Bar Association and the Law Society. They do have some views to express concerning the use of the former French mission building. Now, so this building will be for law-related office use. I have no objection to inviting deputations to come to meet us on this matter. And of course, the deputy chairman can also suggest some deputations for our consideration. Ms. Elizabeth Quat. We had a discussion 1 or 2 meetings ago on protecting the sexual abuse case victims during court proceedings. So can we follow up? Now, in fact, when we met the LLC, I reflected the concern to the Secretary General of the LLC and also the S4J. In fact, I also said that you were very concerned and you had been following up on the matter. I understand that their response is positive, but then they haven't given us a concrete reply. And I think we need to follow up on this matter. And I think we can include this in the list of outstanding items for discussion. As this is a matter which we have been following up on, can we have an early discussion or follow-up discussion on that matter, please, Chairman? So, Ms. KWOK, is it that you want to have a follow-up discussion at our July meeting? Or will you be satisfied if we include this item in the list of outstanding items for discussion? As the chairman of the AgendaI panel, I have written to the judiciary expressing or reiterating members' concerns. And the judiciary has told me that our concerns and suggestions and comments will be given very serious consideration. So it's very likely that the judiciary will consider our views in a positive light. So perhaps we should allow the judiciary some time to consider the matter. Maybe they will come up with some policy proposals. So do you agree that we should do this? I want to say that we'll definitely follow up with the judiciary on this matter, which is a very important matter. Then item 3 on the agenda, and I understand that this is a matter of great interest and concern to the panel. And that is proposed creation of judicial post and a non-civil service position in the judiciary and strengthening of the directorate structure of the judiciary administration. So we've got paper CB 48221314-03, Judiciary's paper on proposed creation of judicial posts and a non-civil service position in the judiciary and strengthening of the directorate structure of the judiciary administration. And then CB 48221314-04, paper on judicial manpower situation at various levels of court, prepared by the Electoral Secretariat. Now, this panel has asked the judiciary for a paper on the mechanism to deal with complaints against the conduct of judges. And we've got paper, a paper on this matter, and in fact the paper was issued to us on the 18th, and it's quite a lengthy report, and I would like to invite members to read that report, and we may follow up in the future. All right, so concerning the creation of 7 permanent judicial posts, 1 non-civil service position, and 2 permanent civil service posts at directorate level. I would like to welcome our guests from the judiciary, and I would like to invite Ms. Emma Lau, the JA, to take us through the paper. Thank you.
Now, the document covers our three major proposals. Now, at the Finance Committee, I told members that the JA reviewed its establishment in 2013, and we feel that we need to enhance the number of posts. And the document explains that in respect of the Court of Appeal, there is a deficiency, so we propose 3 posts of Justice of Appeal, of the Court of Appeal, and also given the large number of cases and the high level of complexity at the initiative of the Chief Justice, it's felt that we need to step up the judicial education, so we propose to add a post of Judge of Court of First Instance, 1 post of Judge of District Court, 2 posts of Magistrate, and so that there can be broader participation in training and education. And also, because of reforms of 2013, there is an executive board of the Judicial Institute, and at the instruction of the Chief Justice, it's felt that there should be administrative organization, and there should be a non-civil servant. It would be manned by a non-civil servant of D3 level, and we hope to establish an administrative structure that will support the training, judicial education efforts, and to provide more research support. And finally, there's a proposal at the Judiciary Administration. We want to enhance the technical support in IT and in financial management. We need there have to be 2 directorate posts, permanent directorate posts, to support our IT strategy plan, or ITSP, and so that we can have better financial management. Now, in respect of the posts of judges and judicial education, the document has been quite exhaustive. I will be glad, however, to answer members' questions. Thank you, Ms. Lau. 2 members have raised their hands, so I will let you speak for 5 minutes each. Raymond Wong first. Now, the Financial Secretary in this year's budget issued a warning that there will be a structural budget deficit in several years, so he will not raise social welfare expenditure to a large extent. In fact, there is less poverty alleviation, so many people complain. But the new administration kept increasing new posts. Now, of course, in July 2012, we voted down the new administrative structure, but in 2 years, the government has increased the number of posts by over 44,000, including 90 directorate posts. They increased expenditure by $3.6 billion a year. So the LegCo has to be very careful. Even if it's the judiciary, we cannot offer an exception. Of course, a good judiciary system is very important for the rule of law. there should be enough resources for them to provide professional service. For instance, in 2014, in the amendment to the legislation, now the CFA says that there are too many cases with insufficient evidence. Now, I feel that we cannot reduce our input just because of resources deficiency. Now, here says that the Court of Appeal can borrow judges from the CFI, but this is not very satisfactory arrangement. Now, they are courts of different levels. The level of efficiency has been reduced. Now, the 51% of the cases were handled by divisions or courts where there are one or more judges from the CFI. So this also disrupts the work of the CFI, where also there's a big backlog. And there have been no rulings on very important cases. Now, the number of Court of Appeal cases hasn't increased significantly, but the judiciary says that one cannot merely judge by the number of cases because some cases are complex. But well, we can't say that cases will keep getting more complex. That is a questionable argument. In common law, the law becomes clearer as cases develop and judges become smarter. And yet it says that Court of Appeal cases are getting more complex because the interlocutory matters, etc., are getting more complex. But you need reforms apart from increasing manpower. So don't you need manpower? The CFI is dealing with more and more lengthy and complex issues. Why does that happen? You need reforms. Instead, you try to get money for new posts. It doesn't make sense. Now, I support the increase of posts. I wouldn't vote against it. But Para 25 mentions that the Judicial Institute is going to have a new post. I'm against that because it says that there will be professional support to JJOs. What is that professional support? The judges make their rulings independently. How come you need a judicial institute? And item B says that there will be certain services required. Now, the universities conduct research as well. The Judicial Institute doesn't need to set up a research division. The judges need to be independent. They can rely on the submissions by the lawyers. They will be required to provide assistance to the court. So I'm against this post. Ms. Lau, any comment? Now let me try to respond and to clarify. Firstly, on the first part, on the increase in the number of posts, the document is already very detailed. I merely want to mention one or two additional points. Firstly, we agree that right now in the Court of Appeal it's not desirable to have so many additional judges from CFI, so that's why we made this proposal. This is our direction. We hope that the picture can be more clear and satisfactory. Also, the cases are getting more and more complex, just as society is becoming more and more complex. So the judges need to spend reading dates, and they also have to write judgments, and so there are less days available for listing, and the waiting time gets longer. So to address the issue of long waiting times, we need to increase the establishment. And in respect of CFI, there are more laws and that the judges need to study. For instance, in the CFI, we are planning on a tribunal on competition matters, and laws are being amended all the time. So the complexity and volume keep increasing. Of course, the judiciary administration also finds ways to increase the effectiveness of case handling. Now, the civil justice reform has been moving in this direction, and since the proposals of that reform have been implemented, new measures have been introduced, such as the promotion of mediation. We try to reduce unnecessary interlocutory procedures. All these are helpful, and we also thank the support of LegCo and its funding, so that in the coming 6 to 9 years, we can take forward our information technology strategy plan, so that our services and work procedures can be more efficient. I think these long answers are merely repetitive of what's in the document. Now, you are talking about numbers, but you're not talking about the quality of the people. As I said, I will not oppose the number of posts apart from the staffing at the of the Judiciary Institute. Mr. Wong, your time slot is up. I'd like to respond. Now, first I want to clarify the Judiciary Institute administrative structure. Now, the professional person, right now, the supporting staff have no legal qualification. We believe that this support staff in the administrative structure is to support the judiciary education. So his judiciary background will be important. He doesn't actually work for judges, but because of his legal qualifications, and also because he has some experience in this field and in training and education, so he is able to take forward the judiciary education more effectively.
We don't have too many members queuing up, and so I will err on the relaxed side. And in fact, I'm also interested in this topic, and I will follow up. Mr. Dennis KWOK, is it that I will also get 10 minutes? Now, as only 2 members have raised their hands, I will err on the relaxed side. So please ask your questions, Mr. KWOK. I want to know why so few new judicial posts are proposed. Look at the CFI. You can see that, in fact, on the list, in fact, most of the judges are deputy judges. So why is it that you're only proposing that one more CFI judge post be created? Ms. Lau, yes, thank you. On the list, there are many deputy judges. There are some reasons for this. Now, maybe some CFI judges are acting as additional judges in the Court of Appeal. And also, we have vacancies in the CFI judges establishment. Why is it that we are only proposing one new post? Now, I think we need to put forward establishment proposals prudently. And if we can have 3 posts of Justice of Appeal created, then that would mean that fewer CFI judges will have to act as additional judges at the Court of Appeal level. And also, we're going to launch another recruitment exercise concerning CFI judges in the second half of this year. So, in other words, you have 7 vacancies, and then you are proposing one new post to be created. That would mean 8 vacancies. So there will be 3 posts of Justices of Appeal created, and as a result, 3 CFA judges may be promoted to the level of JA, and as a result, there may be a total of 10 vacancies in relation to CFI judges. And that was why, Chairman, I said there would be a recruitment exercise later this year. And we're only proposing one new post of CFI judge in this exercise. And I want to say that concerning our establishment review, it doesn't mean that we have already done it and will not do any reviews anymore. There will be reviews at suitable times in the future. And my second question is this. There is a very serious problem of shortage of judges at the moment, and I hope that the JA will keep the matter under review. I hope that the court waiting time can be reduced, and I also hope that the workload of judges can be reduced to reasonable levels. And then may I now refer to para 22. So the Judicial Institute will be set up. And as a result, there will be protected time for judges to attend training sessions. And I think this is a very good idea because judges also need ongoing training. And so does it mean that you need one more CFI judge post? Yes, Chairman, I thank the member for supporting the concept of protected time for judges. Perhaps I can give members a bit more background information concerning judicial training. Now, in the past 2 years, upon the instruction of the CJ, we carried out a large-scale review. The CJ appointed a retired Justice of Appeal to carry out the study, and he carried out a very detailed study. He made reference to overseas practices. And the recommendation is that protected time should be given to judges. Without protected time, it will be difficult to have sustainable and systematic development concerning training for judges. And so we propose to provide protected time for judges at different levels. They will not need to sit. They can or sit at trials. They can take part in training activities, or they can take part in the planning, preparation and delivery of judicial training activities. So that's the essence of the concept of protected time. Thank you. Chairman, I want to know whether this concept can be further extended so that time will be allowed for judges to write their rulings. You know, sometimes people have to wait for a long time for the written rulings. According to the judges, they don't have sufficient time. So to write their written rulings. So can the concept of protected time be extended to cover time for judges to write their written rulings? But of course, if protected time is provided to judges for this purpose, that will have implications on judicial manpower resources. Yes, Ms. Lau, please. Chairman, thank you. In fact, judges can apply to the leaders for time to write their rulings or judgments rather. Now, say for example, some judges may need to write a lot of judgments, and they may not have sufficient time, and so there is a mechanism for judges to apply to their leaders for time to write judgments. Are there other members queuing up to ask questions? Yes, but I'll let you ask one more follow-up question. Chairman, so judges have to apply for time to write their rulings. So protected time is not provided to judges for writing judgments. And I think you understand that the workload of CFI judges is very heavy. And so can protected time be provided to CFI judges without requiring them to apply to the leader for such time to write their judgments? Chairman, thank you. Of course, CFI judges can apply to the Chief Judge of the High Court for time. And also, say if a trial has to continue for a certain number of days, then time will be set aside for the judge to do his preparation work. But then for the details, I'll have to clarify with the Chief Judge of the High Court. But I understand that there are already general guidelines with regard to listing. In other words, time is allowed for the judges to prepare for hearings and to do other related work. Mr. Albert Ho, yes, I think the right... concerning the writing of judgments, I want to say that for some cases, we had to wait for over 6 months for the written judgments. I've come across some of these. And also, for family court hearings, if the trials overrun, so to speak, it will be very difficult to find time to continue the hearing. So on one occasion, the trial was supposed to last for 5 days, but then the trial overran, and as a result, subsequently the trial was conducted intermittently whenever the judge had time, and as a result, the trial spanned over 4 to 5 months, and even Saturdays had to be made use of for trials. And then for concerning litigants in person, in other words, unrepresented litigants, if they are involved, then the trials tend to be longer. So to a certain extent, it's in fact better to provide these people with legal aid. Because for cases involving litigants in person, the court time required is much longer, and the quality of judicial work may also be affected. And I know some judges who have to do their homework in the evening at home, or over the weekends, or during their holidays. And I think that will affect the mood, the temper, and the concentration of judges when they sit at trials in the daytime. And their performance may also be affected as a result. And this is highly undesirable. And I think their workload is really too heavy. Ms. Lau. Yes, thank you, Chairman. Concerning the very heavy workload and pressure at the family court, yes, I can understand that. And also, for family court cases, even though you may think the trial has already been completed, other applications keep coming in. So I understand that the workload at the family court is heavy. In fact, we've already reported to members that we are in the process of reviewing regulations on family court cases. And of course, we'll also be reviewing the judicial resources required. So I thank the member for his concern. So we will be carrying out the review, and we will also be working out the manpower resource implications, and we may come up with some proposals for members' consideration. I'm of the view that the establishment in the judiciary needs to be reviewed. I understand that sometimes you rely on deputy judges, but I think you really should review the establishment in the judiciary. There are more and more court cases nowadays. And also concerning the Judicial Institute, I support this idea. I think continuous training is needed for all professions, including judges. And for even for very experienced lawyers, solicitors, or barristers who have become judges or want to become judges, I think some training in the Judicial Institute will be helpful. But I do not agree that we should follow the example of some countries, and that before someone can become a judge, he has to get proper training and get a degree or a qualification at a judicial institute. Ms. Lau, I think it's a matter of translation.
Judicial Institute.
Oh, in English, it's Hong Kong Judiciary Institute. Now, it's just a unit under the judiciary, led by the Chief Justice, but it's not a school. Now, I also have some questions for follow-up. Now, in your 03 and 04 documents, para 21 is about the Judiciary Institute. Now, you say that under common law, one doesn't have to take continuous training necessarily, but right now we are aware that the judges are laboring and having a very difficult time. They seem to be writing judgments as they go along. So I think it's useful to arrange for some time for them to undertake training. So you in that case, do you increase your manpower? Same in universities. Very often, the teachers are offered part-time day relief, so you would be short of manpower. Now, it seems that in your planned increase in manpower, you did not take this into account. Now, also, it's now almost time for my slot. Now, we need to allocate some time for judges to undergo education, so we need more manpower. So in the Court of Appeal, there will be 3 new posts, and we hope as a result the judges of appeal judges can also undergo training, and also the posts at the CFI and the 2 magistrate posts are also intended to enable judges to have some protected time every year to undergo training or to undergo the planning of training, because some training needs the participation of judges. Now, of course, the universities are experts in training. Now, however, on the judiciary side, would it be retired judges, or would you need to cooperate with other jurisdictions? Now, I think the concept is worth supporting, but how do you implement it, especially in respect of manpower? Now, at the Management Committee for the Judiciary Institute, chaired by the CJ, there are many strategies. For some subjects, we plan to invite experienced judges from abroad to head the training, especially when they are experts on certain subjects. Or we might send our judges to undertake courses or take part in conferences abroad. And also we are planning to invite retired judges to come back and help in providing training. And also we have cooperated with universities, and we asked them to be responsible for certain items. So it's very diversified approach. It meets different needs, and we take the most effective approach. Now, when we met the CJ last time, he said that he hoped that the judges can be trained so that they can work faster and better. But would your training or education be targeted more at the magistracies or at lower levels of courts? Because there the rate of complaints might be higher. Now, there would be different needs at different levels of judges. Now, the needs of the magistracies are, of course, a part of our concern. We have education committee for each level. So, for instance, at the high level, at the High Court level, at the District Court level, and at the magistracies level, there are different needs for each. Now, the magistrates are, of course, our major target because they handle many cases. They are most numerous, and they deal with the largest number of members of the public. So the committees will come up with guidelines, but we need implementation or execution of these guidelines formulated. Now, the governing committee was set up in 2013, but we do not yet have an executive body yet, so the implementation is not that satisfactory. It's not fully implemented, but we're doing our best. Now, we are glad to see that in the document 04, you mentioned the legal assistance issue. Now, we mentioned the experience abroad. We encourage some students to take up these posts when they assist the judges. Now, here in Hong Kong, the judges write the judgments, but in the U.S., very often the legal assistants do the work. Now, in paragraph 11, it says that some outstanding law students are recruited. Now, do you allocate one assistant to each judge? Sometimes information research is required for judgment, and this is also our experience at universities, and the experience and the pressure must be even higher for the judges. Now, that document is prepared by the Legislative Secretariat, probably based on our information. Now, the system has operated for several years. Now, we hope to hire about 6 legal assistants per year, mainly to help the appeal judges. Now, at the High Court, there are the CFI and the Court of Appeal, so the legal assistants take turns in helping both the CFI and Court of Appeal judges. So they mainly engage in information gathering and write memoranda, but the judgments are still written by the judges. Now, in the several years since this scheme has come into operation, the judges involved from the CJ down, all those judges who have been mentors to these assistants saying that the scheme is very worthwhile. So we recruit every year. This year there is some good news, because this year we have been more successful in our recruiting. In September we will have 7 legal assistants who will be taking up their posts. And as explained to members in the past, it's very important for us to identify the right people to fill these posts. So our thinking is that the scheme is operating well and should be continued. Because it has run for several years, we find that the legal assistants can help in certain areas. So this year, 7 of them will take up their posts in September. You have taken up a long time. I said earlier, because there are few people raising their hands, so even when the first member spoke, I allowed him 10 minutes, and you also were allowed 10 minutes, but you have finished asking your question, and Mr. Albert Ho has also finished asking his question. No one has raised their hands apart from you raising for the second round. You stopped in your questions just now before we let Albert Ho spoke. Now you said that time. Now you haven't been proactively recruiting. You are only looking out for people who are interested. Some experienced people may not be able to join the judiciary. So whether it's new graduates or experienced professionals, how can you give them opportunities to join the judiciary? Now, first on legal assistance, it's open recruitment now for CFI. From the CFI down, it's all open recruitment also. Now on this topic, we can discuss till 5:45. So Mr. KWOK, you can now continue. I asked about protected time for writing judgments. As I understand, there is now no mechanism to automatically give judges time for this, but they can apply. But the Chief Judge of the High Court can also allocate the cases accordingly. Now we hope that can be a standing arrangement for protected time for judges to write their judgments, because we know they have a very heavy workload. They need protected time to write judgments. I hope that the judiciary administrator can provide us with a written response. I will consult the Chief Judge of the High Court and then provide a written response. Just now, it's the Judiciary Administrator said that the Judicial Institute is directly, it reports directly to the CJ, is that right? By himself alone? Now, the Judicial Institute has a two-level structure. At the first level, there's a governing body. Now, it's chaired by the Chief Justice of CFA, and then there are other members. Now, the other members of the governing body include the permanent judges of the CFA, including the Chief Judge of the High Court, and also the leaders of the district court and of the magistracies, etc. So the CJ serves as the chairman, but there are other judges or leaders of the different levels of courts. The chief magistrate and the chief district court judge will also participate. They are the members, permanent members of the governing body, and then there's an education committee for each level of courts, and these leaders will chair the work of these education committees, and they will work with other members who make other judges who make contributions.
Finally, concerning IT. So you're proposing to create 2 posts to do the filing of documents on the internet and so on and so forth. Now, the legal sector is in fact very concerned about the progress of the judiciary's IT plan. You're proposing to create 2 new posts. Is that enough? And when will we be able to see e-filing in our courts? And when will we come to a day when we no longer need to make photocopies of a document for the judge, for the lawyers? Can we be using tablets to view certain documents or diagrams? Ms. Lau. No, in fact, we need more than 2 posts, no doubt. But then, as these 2 posts are directorate posts, we need to go to the establishment subcommittee for approval. But then, for other civil service posts or contract posts, or when we need to hire contractors to provide service for us, these posts are not included in this document. So, Mr. KWOK, in fact, we plan to create more than 2 posts, but then only 2 posts appear in this paper. And in fact, most of the expenditure, in fact, for this exercise has been approved in the 2014-2015 budget exercise. And I want to say that it's in fact a 6-year plan that we are talking about. So initially, we need some infrastructure. We need to build up an integrated court case management system. And in order that we can have this system, we need the infrastructure. And after we've got the infrastructure in place, we will launch the system for summonses at the magistracy court level and at the district court level. But we're going to adopt a gradual approach given the scale of the task. We are having a lot of consultation and communication with the legal sector. This is a 6-year program, but at the same time, we have to have some trials and pilot schemes. This process has already started. On the 16th of June, we at the district court level started a small-scale trial concerning submission or e-submission of documents, certain documents by lawyers, and judges can view the documents using tablets. So we are having these trials, and when the infrastructure is in place, we hope to be able to roll out the program in phases from 2016 onwards. Now we can go on with discussion on this item till 5:40 p.m. And I want to have 1 or 2 minutes to summarize. But I still have some questions. Can I ask the last question? All right. You can ask your last question. So we have to wait till 2060 before we can see filing at the district court and at the magistracy levels. Is that right? So the earliest date will be 2016. For the the system. We are talking about 2016. I mean the big system. But then we have already started some trials or experiments. On the 16th of June this year, we started at the district courts a small trial allowing legal representatives to do e-filing for certain types of documents. And of course, the trial is on a small scale. Authorities and submissions. Yes, please be concise. So for the authorities and the submissions, they can be submitted electronically. Yes, there is a special portal for this purpose. I think we need to stop here because we will have to move on to the next item. So, JA, you can see that members are concerned about the Judicial Institute. Yes, there are some ex-officio members, and then this Judicial Institute is to provide training for judges at all levels. But then, does it mean that the court waiting time will be lengthened because judges and judicial officers need to attend training activities and courses? So you have to consider this. And also, please make sure that you'll be able to get suitable persons to fill the post and to provide the training for the judges. And it's important that you have adequate resources in the judiciary, or else people will have to wait for a long time for the judgments, and also court waiting time will become longer and longer. And also, I believe you understand that for the younger generation judges, they do make wider use of IT. So perhaps in the Judicial Institute, you can provide training for judges so that they can all enhance their IT skills. And also, I think there should be training for our judges concerning developments in other jurisdictions. All right, so do members agree that this proposal, this should go to the establishment subcommittee? All right, then I thank Ms. Emma Lau, Mr. Arthur Ng for coming to our meeting. And we will now move on to the next item on the agenda, implementation of the measures to strengthen the governance and operational transparency of the Legal Aid Department and related issues. We've got paper CB 4822-05, the administration's paper on the Legal Aid Services Council's recommendations on the independence of legal aid. And then we have paper CB 4854-01, submission from the Hong Kong Bar Association on the need and benefits of having an independent legal aid authority. We have the English version only. And then papers for our reference, paper CB 4822-06, the administration's paper on progress report on the review of the supplementary legal aid scheme and operation of the 2-year pilot scheme to provide legal advice for litigants in person. And then CB 4822-07, paper on the implementation of the measures to strengthen the governance and operational transparency of the Legal Aid Department, prepared by the Legislative Council, Secretariat. On the 30th of April, the Legal Aid Services Council, LASC, submitted its recommendations on the feasibility and desirability of the establishment of an independent legal aid authority, together with the consultancy study report to the CE. And at the AGLS panel meeting held on the 25th of June last year, LASC and deputations were invited to brief members on the recommendations and to present their views respectively. So today we have people from the HAB with us, and we've got a paper on the Legal Aid Services Council's recommendations on the independence of legal aid, and also the progress report on the review of the supplementary legal aid scheme and operation of the 2-year pilot scheme to provide legal advice for litigants in person. I would like to welcome Mr. Chang Tak Singh, Secretary for Home Affairs, and Mr. Thomas Edward Kwong, Director of Legal Aid, and also their colleagues. So I'll invite the Secretary to take us through the paper, and then I will invite representatives from the Bar Association to speak. Mr. Zhang, please. Thank you, Chairman. So today we are discussing enhancing the governance of the Legal Aid Department and also improvement measures. We look forward to hearing suggestions for improvements from the legal sector. The LASC has set up a task force to review the operation of the Legal Aid Department, the LAD. So there will be recommendations made on how to improve the governance of the LAD and how to enhance its transparency. And this task force is headed by the chairman of the LASC and comprises members from the LASC as well as outside experts in various sectors. The LASC has the statutory responsibility to make sure that the LAD discharges its duties diligently. We will continue to support the LAD's continuous provision of legal aid to those concerned. So improvements include classification of cases, assignment of cases, and so on and so forth, and also Section 9 assignments. And now let me now say something about the administration's decision on the LASC's recommendations. Now, I understand that recommendations were submitted by the LASC to the CE on the idea of an ILAA. A consultancy report was also submitted to the CE, and there was a discussion in this panel last year. Now, the administration has taken into consideration all the views, including LegCo members' views, and we've looked at the structure of the LAD, its operation, its management structure. We are of the view that the LAD doesn't suffer from a problem of independence, and there is no pressing need to set up an ILAA. But of course, improvement measures can be implemented to allay any concern about a lack of independence of the LAD. In fact, there are adequate measures or safeguards in place to ensure the independence of the LAD. The LAD uses only one yardstick in dealing with cases, and that is the means test plus the merits test. The LAD is not affected by financial considerations or financial resources. The HAB doesn't take part in the daily operation of the LAD, will not interfere in cases handled by the LAD. And also under the Legal Aid Ordinance, there is an appeal mechanism. If applicants feel aggrieved by the LAD's decision, then an appeal can be made to the High Court Registrar. We are proposing that the policy responsibility of the LAD D should be transferred from the HAB to the CS's office. In other words, the Director of Legal Aid should be directly responsible to the CS for A. So we will carefully look at the transfer and also the timetable.
現屆政府已經負責多個範疇嘅工作，再增添工作就需要按次序去安排。同時，民政事務局目前正進行多項同法律援助同埋法律諮詢服務有關嘅檢討，包括刑事法律援助費用、普通法律援助計劃同埋法律援助輔助計劃涵蓋範疇同埋財務資格限額，以及為無律師代表訴訟人提供法律意見嘅未來路向等。政府當局需要因應實際工作同埋檢討嘅進度，仔細計劃政策範疇轉移嘅安排同埋時間表，以維持相關政策嘅連貫性，確保有關服務不會受影響。我哋會適時向事務委員會作彙報。主席，我就作呢啲簡短嘅説明。我同埋同事呢
We will report to the panel in time at an appropriate time. Mr. Kwok, anything to supplement? No. And now I invite the Law Society representative, I believe it's Mr. Barreto.
Not the Law Society, as was said over the translation. And in this, I am assisted by Mr. Raymond Leung, Senior Counsel. You have, yeah, it's working. You have in front of you our paper, which deals with one aspect of it, but I'd like to present to you a bit of a review, because there's three papers which I'm going to address very briefly. First question for all of us: what's been achieved in the 1 year since the 25th of June last year, 2013? Well, the main thing that we can see is that the government provided a paper which proved the contention of the Bar Association and the solicitors, the Law Society, that legal aid department's expenditure as a department is actually de facto capped. And this means that there is no obstacle to an independent and accountable legal aid authority. This is explained in our written submission. And what we make clear is therefore this, that back in 1999, the government's objection to legal aid being independent was that no independence because you have no cap. Now we have found that in fact there is a cap, there's a budgetary cap, and that's been made clear in Deloitte's consultant's report. And since there is a cap, there is a case for independence because there's accountability built in. We're disappointed that the papers fail to make this point clear, but our paper makes it clear. Second point is that we, a couple of months ago, reminded the LASC to deal with the criticisms which we made a year ago on the so-called consultant study on the independence issue. The LASC's letter in reply is attached to the papers, and can I just tell you what it says to us in summary? A, our consultants did their usual sort of work, so the inference is a one-size-fits-all is somehow appropriate to this highly complex situation. Clearly wrong. Secondly, B, the LASC relied on those consultants. The implication of that assertion is not our fault if the report by them was flawed. C, what they're saying is, oh, it wasn't too bad a job, but they haven't attempted to address any of the points we make. And what is even more disappointing, that there's no commitment to doing a better job in the future, using the right criteria after we revealed all the faults. So the conclusion, therefore, members, is that, well, what's the outcome? What was done was unreliable and must be redone. Next main point is, Well, what is the outcome that you as a legislative council should be striving for? It's quite simple. Under the LESC ordinance, section 4.5b, the functions of this LESC include advising on the feasibility and desirability of the establishment of an independent legal aid authority. That section makes this an ongoing, mandatory, statutory duty. So that knowing that it's been done inadequately, the LESC has a duty to continue this work, since the previous report was so flawed. Because, you see, this ordinance passed by this council envisages steady progress towards more independence. But instead what we see is more backtracking. We've briefly reviewed the papers presented for this meeting, and they're really rather disappointing. In general, I'm not going to deal with the specifics, but the papers are one-sided and inadequate as to fact and analysis. The papers downplay the real reasons for independence. It's not mere perception without reason. The justifications advanced by the professions are omitted. And some of the key justifications, which are not addressed, are increased efficiency and the increased flexibility and ability to deal with the unmet needs of our changing society. Some examples which are well within the understanding of the Home Affairs Bureau on this is that our society is changing. We have an aging society. What are the unmet needs of our elderly who are in need of legal aid? There's specific provisions that we have provided for reforms on that, how we can help the elderly and their problems and their financial situations where they have dwindling capital and no chance of building it back up again. This is part of the complexity of this issue, which I'm happy to further discuss with the administration as we have over the last 12 years. Another aspect is moving, and a key benefit of independence is moving from a moribund government department to a vibrant, living institution. That's a major benefit. It's not mere perception. So those are just two of the points omitted. There was another interesting revelation from the papers, and that is it revealed a systemic argument for independence related directly to the legal aid staff, which I wasn't aware of before. And one of the objections to the consultant's report, which, in other words, one of the recommendations of LESC, which was actually being rejected by the government, is on the basis that, well, you can't have legal aid staff being vetted by the LASC because they're part of the civil service, and this would damage their promotion prospects when they want to leave legal aid and want to go into other departments where they have better chances of promotion, like, for example, the DOJ or whatever. Now, if that's a concern, as I appreciate it is, surely that means that legal aid staff, as government servants, have expectations that they could be promoted elsewhere. Now, just think for a minute what this has on their mental processes as decision makers. Oh, will an officer with an eye for promotion into, say, the DOJ think, should I make decisions which go along with the administration, or shall I go with decisions which actually are the legal aid and the legal position? It's a tricky position to put a man, and that's the sort of conflict of interest point which I didn't realize was there until it was made so clear in these government papers. So if they don't even want the LESC to vet these people because it'll somehow dampen their promotion prospects, how on earth are we going to promote their independent thinking and decision making on key issues of legal and factual judgment? So that's a major point in favor of independence, which was not seen before, at least not seen so clearly. I think it was actually mentioned probably about 10 years ago. Secondly, the papers fail to mention all the points made by the profession that the consultant study was flawed. And we just make the point that there is no benefit to providing one-sided papers such as these. They don't help balanced decision-making or good governance. So what is the upshot of the 1 year that's passed? Well, there's the paper on independence, which is summarized as 2 no's and 2 maybes. So what it tells us is that for the consultant's recommendations, vetting by LASC, no. Oversight for the official solicitor, no. Overseeing Section 9, maybe. Overseeing refusals of civil legal aid applications, maybe. So 2 no's and 2 maybes. Not much progress. In fact, backtracking in 2 years. We therefore urge this Council to pass a motion that a further review of independence be conducted without the shortcomings of the previous ones, and this done in the coming year without more delay. There are 2 other aspects that I need to deal with. There's a second paper which deals with the progress report on the review of SLAS, the Supplemental Legal Aid Scheme. And basically, my summary of this is no plan, no timetable. It amounts to wait and see. So, no outcome. How long will we wait, and what will we see? There's no vision here, no timetable, no outcome, and yet, just as there was a year ago when I was here, we still have the continuing unrepresented litigants in civil cases, sometimes 50% or more of the cases. Now, in this connection, I would like to refer the Secretary, because I was speaking informally to him before we came in, to the BAR's checklist, which is in our papers, the old papers which are part of the papers today before you. And it's called, well, it's attached to our submission of 26 September 2012. It's called Statement by the Bar Association on the Independence Issue, and also the current situation is an impediment to justice for persons of limited means and sandwich class. This is because we were putting together the issue of independence and lack of meeting the needs of justice. Enclosure 1 is called the Checklist of the Reform Position. This sets out the progress and the lack of progress. So, for example, professional negligence. This was one of our proposals over the previous 12 years, which has been accepted, and there's a few of those for which we're pleased. But that's only part of it. This was part of a package deal, and only bits and pieces are being dealt with. For example, claims against incorporated owners. LegCo supported this, but Home Affairs have rejected this for unknown reasons. And we think this should be... some of them have just been deferred, like the derivatives problem. Huge problem that caused us, as you remember the Lehman Brothers case. Lots of loss and discontent amongst our sandwich class. So this checklist, I would strongly urge the administration review together with the Legal Aid Department with a view to making some real progress in the next few months. The final point is this, criminal legal aid fees. We would like to make the point, this is not just a mechanical exercise of revising fee rates. The scope of the work now required needs to be looked at because of changing judicial requirements. Just as a little example, written submissions are required more and more by the judges because it makes their work easier. But this work needs to be paid for under the legal aid system, not expected to be done for free because it saves a great deal of court time and everybody's time, therefore enhances efficiency of our judiciary, and the whole system works better. But it's really very inappropriate to expect this is to be done for free. So what we're saying, this should be a specific itemized allowance in the relevant schedule. So, Madam Chairman, those are the Bar Association's key points, and we look forward to this Council passing some form of resolution which requires action. Now, that checklist which I referred you to, Madam, wasn't something that sprang just out of the Bar's head. It was the result of months and months, and many of these sessions in the previous room, not just this room, whereby these meetings provided and refined and improved the suggestions, so much so that LegCo was fully behind the package. This was back in 2012, if I remember correctly. So this is not just the Bar Association's work. That is the fruit of the Bar Association, the Law Society, and this Council, these members. So that's why it's as comprehensive and as compact and a package deal that emerged. So I just hope that that can be taken forward as well. Thank you very much.
Mr. Thank you, Mr. Barreto. Right, so I'll now invite members to speak. Dennis KWOK, Albert Ho, Tam Yu Chong, Ho Chun Yin, and I myself, and also Ma Fong Kwok. All right, 6 members in total. Each member will have 4 minutes. Mr. Dennis KWOK. Thank you, Chairman. I want to know, first of all, whether we've invited anyone from the Law Society to come today, and have they told us why they haven't sent anyone here today? Now, our usual practice is to invite representatives from the 2 legal bodies to come. But this is a very important issue, legal aid services. So is it that the Law Society has given us a written submission? No. So they haven't appeared and they haven't given us a written submission. Okay. I thank the Bar Association, Mr. Barreto. For having clearly and eloquently stated the Bar Association's position. This is not the first time. Of course. And then concerning independence of the legal aid authority, the expansion of SLAS, and so on and so forth, I believe the director has heard these views and suggestions many times. Now, the Bureau has not promised to set up an ILAA, but then the Secretary or the Bureau has promised to transfer the LAD to the CS4A's office. Now, concerning the independence of legal aid service, I want to refer to para 4C of the administration's paper. This paragraph is about the appointment of the DLA and the DDLAs. Now, Mr. Paul, the director, has had many years' experience in the legal aid department. I understand that he is supported by many colleagues in the LAD, and I think few in the legal services sector will doubt his independence. But then, concerning the appointment of the director and the deputy directors, I hope that the Bureau can assure us that there is a mechanism to make sure that no political considerations come in the appointment of the director and the DDs. We want to be assured that the director will deal with cases, especially sensitive cases, independently. And maybe we don't have sufficient time today, and so perhaps the director can give me a reply in writing concerning the expansion of SLAS. Mr. Barreto has also covered this point. We hope that SLAS can be expanded on several fronts, so we want to know the progress. right? We have more beneficiaries. Can the scope of the SLAS be expanded? Director, thank you, Chairman. Thank you, Mr. KWOK. Concerning the SLAS, the supplementary scheme, the LASC has already started a review. And I need to thank the Bar Association for the many comments and suggestions. As Mr. Barreto has pointed out, some of the suggestions and comments have already been accepted and the legislation has already been amended. But some of the Bar Association's comments and suggestions have not been accepted. I understand that the LASC has formed an interest group to study possible expansion to the SLAS. I understand that an interest group has been formed recently under the LASC. Mr. KWOK, any further points? Mr. Albert Ho's turn now. Chairman, concerning an ILAA, the idea of an ILAA, this is the wish of the majority of LegCo members, if not all LegCo members. I think we've at least passed 2 motions supporting the establishment of an ILAA. So the LASC supports this idea, the consultant supports this idea. So how come the administration still thinks there is no urgency to establish or to prepare for an establishment of an ILAA? So how come you've decided against this idea? How come you think this is not urgent? Is it that you want us to say that the director is subject to a lot of pressure and so an independent legal aid authority is required? Now, I must say that in fact there is room for improvement concerning the LAD's work, but I think there is room for improvement for the work of all departments. And I want to say that we do appreciate the efforts made by the director. We can see that in some cases where people tried to challenge the government, they were able to get legal aid. But how come the administration is unwilling to prepare for the setting up of an IAOA? Mr. Barreto, you are an expert in medical cases. So we've said this many times. How come when we want to seek expert advice, we can't get expert advice from overseas experts? Why is it that we have to get expert advice from hospital authority experts? Because very often the hospitals are sued, and so there may be a conflict of interest. So how come we have to get expert advice locally from local medical experts? But I don't want to suspect or speculate that the LAD sides with the government, but then people may have the perception that you're not really totally independent. Now, it is said that there is no cap on the amount spent by the department on legal aid cases, but then I understand that there is this, you're subject to the financial envelope. If you don't have enough money, you have to come for supplementary provision. So if the legal aid department has to come to us very often for supplementary provision or funding, then I think the director will feel some pressure, because after all, the director and his staff are civil servants. Secretary. Yes. Chairman, in fact, I think such a request has been made by Mr. Barreto and also has been stated in the bar's submission. But I don't think I can endorse the viewpoints in the submission. For example, para 13. It is said that civil servants are in awe of the financial secretary, and that they are like Oliver Twist, and I beg to differ. I don't think such descriptions tally with the facts. With regard to our Bureau's letter dated September 2013, it clearly states that there is no cap concerning the LAD's expenditure. The Bar Association says there is a de facto cap, but in fact there isn't a de facto cap. But then the submission says that the Home Affairs Bureau's letter supports the claim that there is a de facto cap. I cannot agree. Now, legal aid expenses are met with public funds, and any organization using public funds has to observe fiscal discipline. For example, the organization has to come up with a budget. It has to be subject to auditing and so on and so forth. So any organization using public funds has to use public funds cautiously and prudently. And this is not equivalent to capping or de facto capping. These are two separate matters. The LAD, of course, has to use public money in accordance with established procedures. But then in deciding on whether legal aid should be granted to a case, there is no need to take into account whether the LAD has the money. And it is said that the director, being a civil servant, has to sort of beg the FS for money. Now, I don't agree. There is no accusation that other departments are interfering with the decision of the director of legal aid. In fact, Mr. Albert Ho, Mr. Dennis KWOK have praised the director for his being able to exercise his judgment independently, and he hasn't and there hasn't been interference from departments, including the Home Affairs Bureau. In fact, the former director was also highly acclaimed by LegCo members for being able to make decisions on legal aid cases independently. The Bar Association says that there is a de facto cap. Now, I think the Bar Association wants to increase the expenditure on legal aid. Maybe some feel that if those in the legal sector are responsible for legal aid, then maybe more public funds can be made available. But in fact, that's not the case, because for public funds, we have to follow the usual budget procedure. And then we can see from overseas experience, in the UK, for example, they used to have an independent or legal aid authority. But then last year, it became a government agency again. And some criticized the organization concerning confusion and uncertainty. And then in North Ireland, we see a similar trend. And then in the community in LegCo, some have said that there are some people who are trying to abuse the legal aid system. Now, concerning the appeal with regard to the Hong Kong-Macau-Zhuhai Bridge, and also damages in relation to minibus accidents. In fact, I have in this council on a number of occasions tried to explain to members that the director of legal aid and his colleagues have been acting impartially and independently and have never sought to transfer interest, so to speak, to a small number of lawyers. And so if legal aid is controlled by the legal services sector, will the public really have confidence in the system?
有啲説話
Strongly object to certain words of Mr. Zhang. They insult the legal sector. If you feel that certain people improperly take up public money, then you should make a report on those cases. You must not attack the legal sector with a broad brush. And he likes to quote the case of Zhuhai Macau Bridge. That was approved by the secretary. And you cannot say that the Bar Association's comments to improve legal service is for the profession's own interest. Now, it's an issue of access to justice. You can't say it's to serve the interests of individuals or that of the association. Sorry, the other members have raised their hands. I must let them ask their questions. Next, Mr. Tam Yu Chung, and then Mr. Ho Chun Yin. I've listened to the secretary. I think there's no problem. I think he merely related some circumstances and concerns. I have similar concerns. Recently, I asked this question in LegCo. Now, the refugees, when they applied not to be sent back, some of the applicants tried to delay the procedures by being absent from court. Now, can the legal aid department urge or supervise the representing lawyers to reduce this type of situation or the occurrences? Also, we also saw many judicial reviews. Now, there's a similar case in the Zhuhai Macau Bridge. So I think if you want the legal aid authority to be independent, we will get even more concerned about this. We think there's no need, no urgency. And also, if the Bar Association says that the IOA should be able to spend without a cap, this is impossible. We must be careful. It's all public money. Now, as for the transfer of the supervision from HAB to the Chief Secretary's office, I think there's no problem. And if there's no transfer, I think there's no problem either. Now, the HAB's work, I don't think there's any problem. And also, the legal costs can fluctuate. So the government will fund accordingly. That's very reasonable. The Secretary, Albert Ho, said that I was unfair in my comments. I was saying that the community and LegCo members have raised these queries. I must, on behalf now, I am defending the Director of Legal Aid. I was saying that some people voice these queries. The Secretary was relating to the verbal question. The Director, I thank the Chairman. I thank Mr. Tam for his question. Now, 2 points were made. First, concerning the sort of cases where the refugee was absent from court, so the procedure was delayed. Now, actually, our department did monitor each case, the progress of the case. Every time we appoint a lawyer, if any applicant causes a delay in the procedures, we will consider whether to continue with the aid. We cannot tolerate deliberate efforts to delay the case. Now, concerning the soliciting of business by lawyers, we have set up a committee with the ICAC on the system of appointing outside lawyers, and we have held meetings with the Law Society. We want to see how we can strike a blow in the future against this phenomenon. Next, Mr. Ho Chen Yin. First, I'd like to ask the Secretary. Just now you answered that there's no cap. You clarified that. Now, I'd like to ask. Now, last year and the year before, the expenditure on legal aid, how much approximately? Now, if the upper limit was exceeded, I don't mean the cap. I mean you exceeded the amount budgeted for. Where does the money come from? Does the HAB allocate more funds from its coffers? Now, I was talking about the cost for the lawyers, that is when we outsource the cases. Now, in 2012, it's 460 million, and in 2012 to 13, it's 512 million, and then in the following year, it's $570 million, so there has been an increase. Now, on the upper limit, now on the expenditure of the legal aid department, there is no upper limit. At the beginning of every year, we make a budget on the expected expenditure. Now, if it turns out to be insufficient, we can get a supplementary provision, but that rarely occurs. Many years ago, when we dealt with the Vietnamese refugees, that happened because there was a sharp increase in number of cases. We budget on the basis of a wide range of information. Now, on the supplementary pool, when there is other cases of going above the budget, do you get that from the HAB? Now, if we do need a supplementary provision, then at the HAB, they have a funding arrangement for us. I need to also follow up. Now, right now, the Finance Committee is also concerned. Now, if you make this department independent, then the budget is exceeded and they need to come back to LegCo for funding. Will that cause delay to the cases? Now, I can share with you that there are cases abroad where the legal aid department is made independent. Now, the Netherlands is one example. It appears successful superficially, but actually they narrowed the scope of their service, even though they didn't have to ask for more money. Now, I've seen the cases of ILAA abroad. There is no case where there is no cap or upper limit. Now, the administration seems to say that if the funding is inadequate, then the service may be reduced or constrained. So I would not support the proposal. Also, I'd like to ask briefly. Now, the service. Okay, sorry, my time is up. Now, there are two other members. They are not in the room. Now, I have queued up, so I believe I'm the last one. Now, in the past few years, we hope to extend the scope of the legal aid service. Members mentioned Lehman Brothers or medical cases. There are needs in community, and in my first term, I also said that I hope to expand legal aid. And when Hong Kong people encounter major legal problems on the mainland, we hope that we can provide legal aid. Now, of course, I also support that we can try to allocate more resources, but we must be more flexible in the categories of cases like dentists or apart from possible expansion of the number of categories. Also, in this panel, information has been laid that in one case, the individual cases, the legal costs can be over $40 million. Now, these are so-called big cases. Now, those lawyers who participate, this may be a big honor to them. Now, the legal sector has limited pie. Some people apply for legal aid and they may not be approved, may be the wrong category or low chance of success. And some lawyers say they queue up and they never get a turn. Maybe it's a question of why is the pie not enough to share. Now, can there be a reasonable upper limit? Now, 10 million or 20 million? Now, if a lawyer is committed and now, right now, in a sense, you have no management. Now, if you come back for money for cases of 4,000 or 5,000, now, of course, nothing is free. If you want to engage a good legal professional, you have to pay. But if it's $10 or $20 million, it's a lot. And if they are able to participate, it's an honor to them. So maybe you can share out the pie or cake more evenly for smaller cases. We thank the chair for her views. Now, for individual cases, we don't set an upper limit. Of course, in some cases, the cost can run up to a high figure. Very often, the case was lost in CFI, and then eventually it goes to CFA. So that's why it's so costly. And at every stage, we consult the counsel to see whether there are sufficient grounds for appeal. Now, the expensive cases are usually the big cases where there are many different parties or defendants. Now, we have seen cases where the accident may not have occurred in Hong Kong, but it's in relation to a Hong Kong company. So we don't think it's possible to set an upper limit for all cases, but members seem to be saying that if a certain lawyer, now, if the income for that year for that lawyer is already up to $10 or $20 million, then maybe you can consider giving that case to somebody else. No, what I mean is, can you have some sort of financial case management? So I must exercise my discretion to extend the meeting by 15 minutes with your support. Now, Ms. Ann Chang has come back. She has been in the queue, so I'd like to let her speak.
Yes, Ms. Chang. Thank you, Chairman. I was in another conference room. There was another meeting going on at the same time, because of filibustering, we have a bunching of meetings. So there is a paper on reviewing the supplementary scheme. Chairman, on the 16th of December 2013, we said that concerning those not eligible for legal aid, we asked what assistance could be given to them. Now, for those who have assets of less than $200,000, whatever, they can get legal aid. They can seek judicial review. But then, for others who are hardworking, they may have a flat costing with a price of hundreds of thousands of dollars, and they can't go to court unless they sell their flats. And then there are these people who are non-locals. They come to Hong Kong to seek refugee status, and again they can go to court with legal aid. But then the middle class, the sandwich class, they can't get legal aid. Yes, many in the sandwich class and in the middle class are of the view that they pay tax, but then they are not covered by legal aid. So what is your response, Director? Yes, thank you, Chairman, and I thank Ms. Chang for her question. As I have said just now, the LASC is looking at possible expansion to the supplementary scheme. And so I'll reflect this concern to the LASC. Anything from the Secretary? No. All right, I think we don't really have sufficient time. I think I'll invite Mr. Barreto to...
Briefly,
Yes.
we only have like few minutes. Thank you.
Right. The Secretary, I'm glad to say, has read our submission and clearly, therefore, is making points which support our case. What he's saying is, in fact, a distinction without any difference. It's made very abundantly clear that there are financial controls. Great. I'm not saying we're against financial controls for the legal aid. All I'm saying is that if there are good financial controls now, so they will be equally so when there's a budget with an independent authority. So there should be no obstacle on that accountability point for the future independence. So basically that point is now dead. The administration makes it abundantly clear. Even Mr. Tam Yu-jung made that abundantly clear.
Okay.
The second point is basically that let's look forward. Let's see how we can improve this. Let's see how we can improve the sandwich classes lot. I mean, there is a great potential for improving the legal aid department. Everybody knows this. We've seen this for 10 years. I've spent 10 years of my life in the LASC working on this. So that checklist, which I've referred you to, and I hope everyone's put a yellow sticker there, isn't just the bar's work, it's the LASC's work as well. The work from 1996 to 2006 is built into that. Also the work in this chamber. So let's look at that with a positive outlook, see how we can improve the access to justice in many ways to many of our deserving people. I think that's the key objective of this meeting. Thank you.
好多謝Mr. Barreto。我諗呢就係
Thank you, Mr. Barreto. Now, in fact, in the last term, we had an annual discussion of the legal aid issue, and in this term, again, we have an annual discussion of the legal aid issue. Now concerning Hong Kong people encountering problems in the mainland, and also concerning the sandwich class, the middle class, they also need help. But then at the same time, we understand that public money has to be used and spent wisely. So we have this pie. How can we make sure that there is fairness? I understand that there are different views in the legal sector and also in the community. I thank the Secretary, the Director, and the Bar Association for coming today. So, in fact, the various legal aid schemes have been expanded, and I think that's the end for today's meeting, and the meeting is adjourned now. Thank you.